I'm set for oral argument in Shinn against LeMaire, Real Party and Interest Rentaria, our cause number 1CA SA21-0185. Counsel, I appreciate your appearing for this argument virtually. As you'll notice, there's no clock on the screen. Each side will have 20 minutes for argument. Petitioner may reserve as much time of that time as you wish, subject to watching your own clock. And should anyone exceed the 20 minutes, I will jump in. And with that, we can begin with the petitioner.
Thank you and good morning. My name is Nicholas Sato, and I'm arguing today on behalf of Director Shinn. I will try to reserve at least 5 minutes for rebuttal. Director Shinn has the exclusive authority to develop and maintain a parole system for ADCRR inmates. That statutory authority includes the responsibility for classifying and certifying eligible inmates for parole. On August 17, 2021, Judge LeMaire infringed upon that authority and ordered Director Shinn to certify Mr. Rentaria for parole. Mr. Rentaria does not dispute that his sentence does not authorize parole. Indeed, it does not. And so the purported basis for the order enjoining Director Shinn to certify him for parole is patently wrong, and consequently, the order itself is arbitrary and capricious.
Well, let me interrupt you for a moment, because while this case certainly has overtones of some very interesting and important statewide issues, I am concerned that there is a procedural issue here that we need to discuss first. And that is that the state, qua state, not Director Shinn, but the actual state, never appealed the first order entered by Judge Herod. And I don't know how we have the jurisdiction to consider the merits at this time.
You're correct. Maricopa County, on behalf of the state, in its role as the state prosecutor, did not file an appeal from the May 2020 order. The jurisdiction for this court is 12-120.21A, 4, which confers jurisdiction to hear and determine petitions for special actions. And that's what we have here today.
Yes, but while we've exercised special action jurisdiction in any number of contexts, I can't recall having done so when the time to appeal is years expired.
Well, special action jurisdiction is discretionary. And I believe that there's equitable considerations that go into that, namely the May 2020 order that derived from a Rule 32 criminal proceeding. Director Shinn was not a party to that proceeding. The state, as the Maricopa County Attorney's Office, as the prosecutorial arm of the state, was a party. If you look at Rule of Criminal Procedure 32.14 and 32.16, those are the rules that authorize appeals in Rule 32 proceedings, and it authorizes any aggrieved party. And when you look at the definition of party, it in that same rule, in Title 13, for the Rules of Criminal Procedure, it defines it to mean the state of Arizona or any other entity, and it contemplates that it is extended only to the prosecutorial body, which is Maricopa County Attorney's Office. So it's our position that Director Shinn, because he wasn't a party, didn't have a means to file a petition for review. He wasn't a party. And frankly, that's just not his function to appeal from Rule 32 proceedings. He is a custodian of inmates. And as I mentioned, he is responsible for parole policies for ADCRR. And to exercise special action jurisdiction, this court can consider a lot of things. Not only was he not a party, as far as the timing, as the transcript reveals, this was an order that went into ADCRR's time computation unit, and the folks didn't understand that there was this this order to actually release him or certify him for parole. So it only became clear to Director Shinn in August of 2017 when he receives this order saying, come appear in my court and you need to show cause why you didn't comply with this order. At that point, he had adequate notice. He appeared. and he defended against the merits of the argument. He ultimately lost that. Judge LeMaire just defaulted to what Judge Herod had done. But once that ruling came out, and
I'm sorry, but did Judge LeMaire have any discretion to do anything else? That was a final unappealed order. How could a new Superior Court judge come in and disregard it?
Well, I think it was in the context of an order to show cause. I'm sorry, a motion for an order to show cause. And I do think she had the discretion to look at that order to determine whether or not it was a typographical error, whether it made any sense. I mean, the Maricopa County actually asked Judge LeMaire to transfer it back to Judge Herod for clarification. She certainly had the discretion to do that.
Well, she had the discretion not to hold Director Shinn in contempt, and she exercised that discretion. Clearly, Director Shinn has an interest in not being held in contempt, but as to who is eligible for parole, who is incarcerated, if Director Shinn objects vehemently to the conviction of an individual and does not want to incarcerate that individual, Director Shinn has no discretion to disagree with the court. And so here, I think the court probably rightly found that Director Shinn was not acting in contempt of a court order. And it seems to me that's about as far as Judge LeMaire was able under the law to go. It would be deeply concerning if Superior Court judges were able to disregard former unappealed orders of other Superior Court judges and just, for example, start releasing inmates willy-nilly. That sort of authority does not exist. And so I'm not sure that Judge LeMaire really did exceed any authority she had.
Well, we're certainly not arguing that Director Shinn has the authority to ignore a conviction or a lawful sentence. And we're not, that's not before the court, and we're not asserting that. He's not asserting that authority. The issue here is that Judge LeMaire reaffirmed Judge Herod's order. And I do believe that she had the discretion to reconsider that or to examine it and decide whether or not it was an error. I'm not aware of any hard and fast rule that prevented her from doing that. She not only she didn't just decline not to look at it, she affirmatively reaffirmed it.
Well, counsel, which rule of procedure are you looking at to say she had the authority to do that?
I think it's an
what rule?
I believe it's inherent in every Superior Court judge's authority.
You think every Superior Court judge 2 years after the fact, when someone else comes in and says, I don't like what you did, or someone else did, can just change it?
If there's good cause, sure, yes. I'm not aware of a hard and fast rule that says that they cannot.
Well, don't we have a rule of finality that says once an issue is no longer appealable, it applies?
I think the rule
unless you have a grounds for getting around finality.
Again, I think the rule of finality is also, it's not inflexible. I believe there's some flex there, and if there's a good reason or good cause to look at something, I think that a Superior Court should, especially in this instance, when you look at the four corners of Judge Herod's order, and it doesn't make any sense. It doesn't make any sense for him to say, where the original sentencing order says without release, and then he just says, I'm ordering you to initiate him to be eligible for parole. I mean, something like that is so patent. I believe that's why these rules, there is some flexibility.
But wasn't the person responsible to deal with that patently wrong problem the state? And the state of which you're a part was represented at that point by Maricopa County. They were the state actor, and they didn't appeal it. So why does the state, through your client, get to come back 2 years after the fact and change it?
I think that the order implicates several of the state's governmental levers, right? You've got the prosecutorial arm, and Maricopa County could have appealed that. I think that the order requiring Director Shinn to initiate parole proceedings infringes on some victims' constitutional rights. And I believe the Maricopa County Attorney's Office has
victims here to contest that.
The victims never had notice of this, as far as I'm aware.
So I mean, you haven't given them notice either of these proceedings.
Not that I'm aware.
So you really can't invoke victims' rights at this point, can you?
Well, what
You're
I'm,
not here, you're not here to represent victims.
no, I represent Director Shinn. My point
Okay.
is,
But let me go back then, one other point, and then I'm going to allow others. I don't want to take up too much time, but Director Shinn got the order. Now, your argument is it wasn't somebody high enough in my organization for me to pay attention or for Director Shinn to pay attention. But the DOC was given the order and didn't do anything for 2 years. Am I missing anything there?
well, I'll just take issue with part of that. One, it wasn't quite 2 years. It was just a little bit over a year. Two, if we're going to deal with the timeliness of it, I mean, you've got to fit it into one of the jurisdictional statutes that require a timely direct appeal, 20 days, 30 days. And it's our position that we're filing a petition for special action. But we're not invoking any jurisdictional statute in which there'd be a time limit that would bar an untimely appeal. And there's no timeliness.
There's no such thing as special action relief without some underlying statutory basis. We don't just say special action and we can do whatever we want. You have to have something more.
Well, I would disagree with that. 12-120.21, jurisdiction to hear and determine petitions for special actions without regard to its appellate jurisdiction.
Well, but you're special actioning Judge LeMaire's order, right?
That's correct.
And Judge LeMaire merely held that your client is not in contempt of court and essentially recited what Judge Herod had done. So I don't even see how you're aggrieved by Judge LeMaire's order.
Well, she reaffirmed it. She reaffirmed the order. There's another difference between Judge Herod's order and Judge LeMaire's order. Judge Herod's order was sort of a future enjoyment. Upon service of 25 years, ADC must institute parole proceedings. Upon service of 25 years. At that point, Mr. Renneria had not served 25 years. His 25 years had been served after that order. And so when you flip to Judge LeMaire's order, it is a more direct express must institute parole proceedings. I mean, so that's another difference between the two orders. One was sort of it was a future prospective look, and Judge LeMaire's was an immediate do it now. But again, we're in the special action realm, not a direct appeal realm, not a Rule 32 appeal. Those rules, I would concede, would have some time limit issues on that. Special action petition does not. You have jurisdiction to consider it. I believe that there's equitable considerations to just not disregard it out of hand. Going back to Judge Swan's question about whether or not the director has the authority to ignore convictions and sentences, he does not, and that's not what we're disputing. Here we have Judge LeMaire was the first one to bring him into court and ask him to show cause why he did not comply with the prior order that it's our position was not fully understood when it was issued. The fact that Maricopa County may have or could have appealed and did not appeal, that should not, I'm not aware of any rule that would preclude Director Shinn, who has a separate interest in this. They may have some overlapping interests, but they certainly have separate interests. Maricopa County has an interest in victims' rights. Maricopa County has interest in seeing that convictions and sentences are just. Director Shinn has an interest in overseeing a direct statutory responsibility to ensuring that the parole policies within his department are developed and maintained and followed. And that's where I believe there's two separate interests. Maricopa County had an interest, Director Shinn had an interest, and whatever Maricopa County did or did not do, I'm not aware of any authority that would bind Director Shinn or preclude him or bar him from challenging his legitimate challenges.
Counsel, on that statutory duty, I just wanted to clarify your understanding. So we're talking about ARS 31-201.01A, the duty to hold in custody all persons who are sentenced to the department under the law and shall hold such persons for the term directed by the court subject to law. And you highlight the subject to law language, or the in the petition, the language is highlighted. Isn't Judge Herod's order law of this case? I mean, isn't a ruling of the court part of the body of law that would inform the director's ministerial function here?
I've got two answers for that, Judge Perkins. The first is I don't think the law of the case is infallible. As I said before, I think that she or any other future judge that comes onto this can re-examine any prior order, especially if it's patently erroneous on its face. I will also direct you to two other statutes that I believe that I'm referring to when I'm talking about Director Shinn's authority. 41-1604, those are the general duties and powers of the director. One of them being maintain and administer all institutions and programs within the department, be responsible for the administration and execution of all community supervision services. I'd also point you to 41-1604.09, and that is the statute that expressly and gives Director Shinn the exclusive authority to develop and maintain a parole eligibility classification system. He is responsible for developing and establishing the rules and for seeing it through and enforcing it.
But is he free to disregard orders of the court that he just disagrees with? I mean, let's say this was a Supreme Court interpretation. Are you saying that this statutory duty is subject only to Director Shinn's reading of what is the law that guides him in this process, and a court's order, even perhaps the Supreme Court's order, is something he can disregard because it does not constitute the law to which this statute refers?
Absolutely not. He cannot disregard any court order. Superior Court, this court's, the Supreme Court. He cannot disregard it. But what he can do is he can challenge it. He can challenge an order. He has standing to challenge.
In perpetuity? I mean, there's no point at which he will have given up that right to challenge it because he failed to do so at an appropriate time.
Well, I think going back to the timeliness in perpetuity, if this, if there was no legitimate basis to file a special action when he did, then no, not in perpetuity. But we think that the circumstances in this case are not unreasonable, considering if there's a timestamp on Judge Harrod's order, it was on a Rule 32 order, it was buried in the order. Director Shinn was not a party to this lawsuit. He is sued in his official capacity and individually in other lawsuits. Those typically go to counsel and they're reviewed. This was a stash in order in something that wasn't even raised by Mr. Renteria.
So if Director Shinn's successor has a very different view of how parole ought to be handled, and there are a number of these orders floating around that Director Shinn has been involved in, can that person then start a whole new round of litigation to undo the plainly wrong results that Director Shinn secured, and so on and so forth as directors come and go?
No, and I don't think
that why is Director Shinn's action final but a court's is not?
Well, the court's action is final. I mean, after it goes through the appellate process,
which it has here, except that there was no appellate process at the decision of the state. But I don't see why the court's orders are subject to being revisited if they're clearly wrong. But Director Shinn's successor can't go back and undo a whole bunch of judgments because that person disagrees with Director Shinn.
I agree with you. I don't think a subsequent director could go back and undo final court orders, and it's our position that this order is not final, that we're still in the process of appealing it. If this court issues a decision declining special action jurisdiction or denying relief, and any petition for review is denied, that's final. It can't go. No subsequent director or Director Shinn can't go back and just disregard it and keep challenging this in perpetuity. There was an order by a Superior Court judge directing him to do something that was solely within his realm. It took away any discretion that he had. It was institute parole proceedings.
But counsel, isn't your argument, as long as he goes back to court and challenges it, then whoever the next director is, has reopened the door? Because you're trying to say that Judge LeMaire's order reopens the door to revisit what Harrod did. And so isn't your argument really that, no, it's a final order, as long as the director, the then director, doesn't file another action trying to change it? Because once they do, they've opened the door and we can go back through this again.
Well, I think finality of an order for purposes of appealing it in the first instance is different from the finality of an order following an appellate mandate that would bar any subsequent challenges. I mean, we are still in the midst of the first and only challenge to this order.
But then what's to stop another panel? Let's say you disagree with the result this panel introduces. Why can't you go back to the next panel next week when there's a new hot panel and say, this department was clearly wrong. We want you to take another look at it.
In the same case with Mr.
Yeah.
Renter's case?
Yeah, in the same, well, that's what you're doing here. I mean, Judge Herod and Judge LeMaire were writing on the same case. If you don't like our result, can you come back next week and find a new panel to undo our result?
No. I think that would be ill-advised. I think that this panel's decision would be binding on any subsequent panel, and that'd be a foolish special action to take up. But I think we just have a difference in frame of mind. Director Shinn didn't come into the Superior Court and move to reconsider Judge Herod's order. Judge Herod issued an order. Director Shinn did not have adequate notice of that order, did not fully understand that order. And the first time that he did, he challenged it. And before the judge that was before. I mean, it went from Judge Herod, and Judge LeMaire said on the record that, once Judge Herod got kicked to a different panel, or I'm sorry, a different department, it kind of got bounced around. Maricopa County is actually trying to get it back to Judge Herod, and she denied that. So it wasn't an issue of judge shopping or trying to take a second bite at the apple. This was the one and only time that Director Shinn had an opportunity to substantively oppose the arguments, and he was hailed into court to do that. He was the one that was brought into court by Mr. Renteria's motion and Judge LeMaire's order. I've already exceeded my time. I'd love to continue talking, but if I could save 60 seconds for rebuttal, that'd be great.
All right, Mr. Bellinger.
Thank you, Your Honor. Jim Bellinger on behalf of Real Party and Interest, Alicio Renteria. To us and to me and to Mr. Renteria, this has always been about the effect of a final order. In May of 2020, Judge Herod issued an order that the state should initiate parole proceedings on Mr. Renteria's behalf after he served 25 years. He was not saying he's eligible for parole, but you should begin that process. There's no question that the county attorney's office received that order, and there's no question that Director Shinn, DOC, received that order. They just didn't do anything about it. And there's clearly procedures in place to address an order with which a party or an entity has a problem. Clearly, the county attorney's office could have filed a motion for a rehearing. They could have done a petition for review, and they opted not to do that for whatever reasons. And I think the reasons they articulated don't even constitute excusable neglect. For the director, let's assume at this point of my argument that he's not. I think Mr. Acedo has made the argument that Shinn is not the state is not Shinn. But let's assume for purposes of this argument that Director Shinn is the state and the county attorney was the lawyer acting on behalf of him. There's no question that DOC received the order. And their explanation for not acting on a final order of the court is that we have clerks read these orders and they may not have understood it. That to me just...
Well, Counsel, is that a valid reason to avoid contempt but not avoid the order?
Absolutely, Your Honor. I believe, and I think that's exactly what Judge LeMaire did. I think she made the ruling that there may have been some snafus here, and therefore I'm not holding you in contempt. But it doesn't negate the impact of a final order. I'm not holding you in contempt for that, but it doesn't negate the impact of a final order. So there's clearly in May of 2020, DOC received the order. And then in the record, if you look at page 77 of the appendix, Mr. Renteria's handwritten order to show cause, it's clear that he did a series of internal kites at the prison to have his parole proceedings initiated and provided a copy of the order. In December of 2020, they responded to him that notwithstanding the order, it violates the law and therefore we're not going to do anything about it. So it's even erroneous to say that there was only one opportunity for Director Shinn to have been aware of this. And there's case law, and there's case law. There's a case called Giglio versus the United States, and I'm not sure I'm pronouncing Giglio correctly, but it's basically you can't have procedures in a large office that allow persons to avoid their responsibility. If there's an order or something that a party to a case or a lawyer working in a case or an entity working in a case is supposed to be aware of, the office has to have processes in place to transmit that information to the appropriate party. So Director Shinn and DOC, as of May of 2020 and thereafter, in the internal administrative process that Mr. Renteria initiated, had a copy of that order. The county attorney, again, let's assume now that Director Shinn is not the state. The appellate statute that governs a situation like this is 13-40324, and it basically says if the state is aggrieved by a post-judgment order, it has the right to appeal. Let's assume Director Shinn is not the state, but the county attorney's office clearly were aggrieved by this order. They don't believe that Mr. Renteria should have parole proceedings initiated, yet they did nothing about it. They did not appeal. They did not move for a rehearing. It sat for months and months until Mr. Renteria actually filed a motion for an order to show cause. So in my mind, this is about the sanctity of a final order and the appropriate process for vindicating. If you believe a final order is incorrect, you have appropriate processes to deal with that issue, none of which were followed here, whether it's Shinn and the state or Shinn or the state. In either event, the order is final. Nothing was done about it.
So, Councilor, are you aware of any case that allows a collateral attack on a final order in this way, where one arm of the state says, well, yes, we're the state, but we're not the state for that purpose, and therefore we get to challenge it again in a collateral proceeding, basically?
I am not, Your Honor. I am not aware of those cases. And in fact, what I am aware of are the cases like State v. Dawson and State v. Montgomery, which basically say, and they're in the context of unlawful sentences. If it's an unlawfully lenient sentence, the means for the state to correct it is to file an appeal. So I'm not aware of the cases that you're talking about, Your Honor, and I've looked for those, and I don't believe there are any cited in Mr. Shinn's briefs.
I didn't suggest there were any. I was asking if you were aware.
I'm not, and if I were aware of them, Judge, in terms of collateral attacks, I'm not aware of any situation like this. In our mind, again, I think State v. Dawson, which is cited in Chaparro, sets a very clear course for Director Shinn and for this court to follow. You may disagree with the order, but it is final. And you should have done something about it previously, and now that order stands and it's not subject to a collateral attack. I agree with what the court has said, and this sounds like piling on a little bit, but I agree with what the court has said about Judge LeMaire had no discretion in a motion for an order to show cause to hold Director Shinn in contempt to change the prior order of Judge Herod. Had somebody wanted that to be done, potentially a motion, a Rule 60C type motion, excusable neglect, something to that effect. But those proceedings were not, and I don't even believe those would have prevailed, and I'm not sure they would have been appropriate, but nothing like that was done. It was, we've ignored the order, and now we're being hauled into court and we disagree with the order. And now we think because Judge LeMaire did what Judge LeMaire did, we have a right to appeal, which frankly, the Court of Appeals already rejected because the order was 13 months old or 15 months old at that point. Or we have a right to special action. Special action cannot be used if there's an equally plain, speedy remedy, and this plain, speedy remedy was an appeal or a motion from rehearing back in May of 2020. The last thing I want to say, Your Honors, is that there's been a flotation of a parade of horribles. If you grant Mr. Renteria relief, hundreds and hundreds and hundreds of similarly situated inmates will flood the courts with petitions for relief. That is absolutely incorrect. This has nothing to do with a legal determination of release or parole and what is the meaning there. Those cases are being litigated, and they're being litigated because appropriate procedures were followed to maintain the jurisdiction of the Superior Court and the appellate courts to deal with that issue. What we have here is, and I've said it in my pleadings, one man who there was a final order issued at this point now, 15 months ago, that was the appropriate process to challenge that order was not followed. And so there will not be a floodgate of persons seeking relief. This will only affect Alessio Renteria, or it will affect somebody in a situation like Mr. Renteria's, where there was a final order stating what a sentence would be, or requiring DOC to initiate parole proceedings, and that order was disregarded, and months after the fact, we're in a situation like this. I am unaware of any other situations like Mr. Renteria's. I articulated to the trial court that I believe this will only affect one person, the real party in interest in this case, and I have not been made aware of anything other than conjecture that this will open the floodgates for hundreds of similarly situated lawsuits. I don't believe that to be the case, and there's no evidence to that effect. Unless your honors have questions, I really have nothing to add.
All right, thank you. Mr. Aceto, you were out of time. As a courtesy, I'll give you 60 seconds and try not to interrupt you, but keep it to 60 seconds, please.
Thank you, Judge Swan. First, whether or not Director Shinn had notice, or whether or not it was excusable that he was not aware of it, is not relevant to this conversation unless there is a jurisdictional statute that sets a timeline in which to file an appeal. Our position that there is no jurisdictional statute that he was able to take advantage of. Mr. Bellinger hasn't pointed to one either today or during his briefing. So the fact that whether he was on notice or not is completely irrelevant. He's filed a petition for special action, and whether you want to treat that as being taken from Judge LeMaire's order or Judge Haird's order, the only question is whether it's equitable or not to accept jurisdiction, and that's solely in your discretion to do so. I would like to cite one case for the court, Ronberg.
Well, why not just take it? I'm sorry, I said I wouldn't interrupt you, but here I go. Why not just deem the special action to be a challenge to the original sentence then?
It certainly can be. I mean, well,
so 25 years ago there was a sentence issued, and now you can special action it?
No, not to the original sentence. No, the statute specifies that to challenge an illegal sentence, you have 20 days to challenge that. That's by statute, and we're not challenging the sentence. We're not arguing that the sentence is illegal. Judge Haird, either Judge Haird or Judge LeMaire, modified the sentence or converted the sentence. The sentence is what it is. So in your situation, the answer would be no. That deadline has long passed 50 years ago. This is a separate issue, and I'll just end by citing a case, Ronberg versus Arizona Board of Chiropractic Examiners, 182 Ares 409. That case explains that Maricopa County, when they're acting as a prosecutor, their actions don't bind other state agencies. That establishes that there is different hats within government, and the fact that Maricopa County did not appeal, or whether they could or not, doesn't bar or bind Director Shinn when he's got a separate statutory obligation. Thank you.
All right. Thank you, counsel. This matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.
Thank you.